Next, from the state capitol, members of the House Pension Committee hear testimony in favor of and opposed to Senate Bill 512. This bill would change pension benefits for current state workers in an effort to reduce the massive unfunded debt facing the state pension system. We'll hear from supporters, including House Speaker Michael Madigan, Republican leader Tom Cross, and former Attorney General Ty Fainer. We'll then hear from union leaders who oppose the bill. This runs about 1 hour and 15 minutes.
Our next item of business will be Senate Bill 512, House Floor Amendment number 2 to Senate Bill 512. Chief Sponsor Representative Cross. See Speaker Madigan, who is also a sponsor of this legislation, coming to the table. Leader Cross, the House Floor Amendment number 2 does become the bill, correct? Yes. Therefore, could you describe Senate Bill 512 as amended by House Floor Amendment number 2?
I will, Mr. Chairman. Thank you for allowing us to present this bill as amended. This is, for the most part, very similar to what we talked about when we were before you last spring, and it's the same concept of moving forward, trying to figure out and assess the cost of staying in Tier 1 if you so choose to be in that system. There are three options under 512. One, you can stay in the current plan, and all three options make an assumption everything you've earned to date you keep. But going forward, if you stay in the current plan, you would pay more to cover the cost of the benefit you're going to receive. You could move into Tier 2, where you would pay less. The benefit would reflect that. Or 3, you could go into a 401 style plan. The significant changes that we have put into Amendment 2 are a result of having some conversations with some people who have offered observations about what we can do to make this better and hopefully pass it. One of what I would call the significant changes is that with respect to staying in Tier 1, that you would see under originally in 5.2 or in 512, you would use the teacher contribution as an example. It's at 9.4. It would climb to I think 13.7 ballpark, and Kevin, you may know the exact number. In the original version of 512, we had a recalculation every 3 years, and that had the potential to go on indefinitely. And people we kept hearing from said there's some uncertainty there, that the migration rate, if you will, would be very high, people leaving Tier 1, and then you would end up, in effect, be doing away with Tier 1. The goal on my part is not to do away with Tier 1, but that simply people pay for the cost of the benefit they're getting. So what we have done under Amendment number 2 is that there would be that initial increase from 9 to the 13 number. There would be one correction after 3 years, and that correction could go no higher than 2 points. So the net result is you would be potentially in the 15-point range from 9.4. Some people would say that's low. Some people would say that's high. But the point is to try to have some certainty and a capping so people know where they are from a planning standpoint. The downside is that it doesn't completely cover the cost of the benefit. And I think you'll hear from some people that will say it should have been higher, it should be higher, and that was the rationale for the original version. But we're in a legislative process. We tried to hear what people were saying, and therefore that is the rationale for Amendment number 2 with respect to the first section. The other area we fixed is concerning Tier 2. Employees are currently contributing more under Tier 2 than we expect they will see in a benefit, and we've tried to correct that or restructure that in this amendment. And 2 is with respect to our commitment to stabilize the systems from the state's perspective, we're going to require the state's contribution to the funds be more than is currently certified. And we're doing that in this, we would be doing that in the first year. Remember, under the discussion of 512, and one of the biggest concerns we have under the current law is under the 95 law that we passed under Governor Edgar, we ended up with a payment plan that I think most everybody would agree would be very hard to sustain. And as you see, by 2045, we get to a figure of $23 billion that would come out of GRF. I think when you hear people talk about the system's in good shape, they make an assumption that the payments are continually made under that 95 law. And as you see under that ramp, that is highly unlikely. So what we have done under 512 is try to stabilize that payment going forward, and it's roughly, Mike, in about the $6 billion range from here on out, and that takes care of the unfunded liability. And then the ultimate other goal is to make sure people for their benefit if they stay in Tier 1, or they have the options as with respect to Tier 2 or 3. So that's kind of it in a nutshell. I think most people remember the discussion from the spring, and with that, I'd be glad to turn it over to anybody else that wishes to speak with respect to the bill. I see.
Let me read just the witness slips for the people who wanted to give testimony. And at the end of the committee, I'll read all the witness slips into the record, but we don't want to go through that right now because they're quite voluminous, to say the least. But we have Tyrone Fainer, who's approaching the microphone right now, President of the Civic Committee, and he is a proponent in oral testimony. Tom Johnson from the Taxpayers Federation of Illinois is also a proponent of House Floor Amendment number 2, oral testimony. And Gary Grasso, who is the president of the DuPage Mayors and Managers Conference, has no position on the merits and does want to give some oral testimony. We have Cordelia Meyer, who's also from the Civic Committee, oral testimony. And, well, it's Dia, but she spelled her full name here, I believe. And Kirsten Carroll, also from the Civic Committee, is a proponent, oral testimony if needed. Mr. Fainer, I don't believe you'll need any help, but if those ladies are available in case, so, but you can proceed as now.
I may well need help, but I think Leader Cross wanted to say one more thing before I begin.
Just one point with respect to the need to do this. We just got a number back from the systems, and they certified them. Our pension payment as we move into the next budget year is going to climb by $900 million. So last year was about 4.5. It goes up by almost $1 billion. You throw on there almost $2 billion in debt service because of the borrowing we did a couple of years ago. So that puts us over $7 billion out of a budget of $33 billion. This isn't an issue of people trying to take anything away. This is an issue of a system that is not sustainable as we move forward. It's a very unpleasant conversation. It's an uncomfortable conversation. And people say, I'm doing everything you've asked, and they're right. And I think about the state employees and teachers, university people, they are right. But as I said back in the spring, there's a lot of blame to go around. There's a lot of people have skin in the game. But if we want a system that's stabilized and we can sustain, we've got to address it as we move forward. And this upcoming year is a classic example of, you have to seriously ask the question, do we have the capacity to pay over $7 billion on top of all the other pressures on our budget, Medicaid being one of them, going on with K through 12, et cetera. So thank you for the time, and I'll defer to Mr. Fain.
Please proceed.
Thank you, Representative McCarthy. I thought I'd begin, first of all, it's nice to see you all again. I testified before you in the spring, and much has occurred since then, and I thought an appropriate place to begin would be to read a statement regarding pension reform that was put out. It was a joint statement of the Speaker and Leader Cross on Memorial Day of this past year. It reads, it's brief. We are absolutely committed to reform the public pension system for current employees. It must be done to stabilize our system and address long-term financial issues for both the public employee pension systems and state government. We believe passage of legislation addressing this issue is essential to the state's well-being. It was made very clear during the May 26th hearing in the Personnel and Pensions Committee that both those who support pension reform and those who are opposed to Senate Bill 512 acknowledge we have a problem and something must be done. Our goal is to enact reforms to our pension system that provide a long-term solution for both those who are members of the pension systems and those who fund them. We will convene meetings over the summer to address the issues and concerns that have been raised and work toward a solution in this year's fall veto session. Since the spring session, numerous and extensive meetings have been held by the Pension Working Group Committee, chaired by Representative Kevin McCarthy. I have attended numerous forums and had private meetings with union leaders, among them, and I've become friends of some of them, believe it or not, including Henry Baer from AFSCME, Cinda Klickner from IEA, Dick Ingram, TRS, Illinois Municipal League, Springfield City Club. That had about 200 retirees and current employees here in Springfield earlier this summer. The Northern Illinois Mayor's Council, about 20-plus mayors, and you get the idea. And this is maybe half of what I have done personally, with the goal of trying to secure approval of 512 or find out how we could make it better. At no point in time or at any meeting, public or private, has any representative of a union or representative of the 5 state pensions made a suggestion as to how to improve or change Senate Bill 512. We've asked, we've looked. There obviously have been numerous hearings where, over 20, I believe, where all the interested parties showed up. A number of the members of this committee here today have been present for most or all of those meetings. And I argued that this is a good bill that fairly deals with a very, very difficult problem facing our state, your state, and mine. I won't belabor things that you're all acutely aware, but I would like to hit a few high points. The debt and unfunded obligations of the state's pension funds is the most important financial issue facing Illinois today. We will not be able to balance the state budget until we reduce the magnitude of these obligations. The amount of debt associated with our pension funds dwarfs every other debt the state currently has. The 5 state pension funds are underfunded by $85 billion, and we have amassed another $17 billion or so in bond debt for pensions that must be repaid. Illinois, as you all know by now, because you've heard it so many times, as have I, Illinois has the worst funded pensions in the nation, even worse than California. The recent income tax increase was insufficient to cover this debt. Without reform, we must either watch it as pension contributions scout other state services, and that's demonstrated by the chart that the leader introduced, or accept responsibility for allowing the pension funds to fail. I don't believe either is satisfactory. It just can't be done. We have to find a solution. At this point in time, no one believes that the 5 state pension funds can meet their obligations. Data from each of the 5 state pension funds shows that their assets are not sufficient to even cover future benefits of current retirees, let alone the future benefits of current employees who are making their contributions, as had the retirees faithfully every week, every paycheck, and into the funds. And simply put, without reform, those funds will run out of money, which would be a tragedy for everyone in Illinois. I want to stress that although it's hard for me to fathom the opposition to this bill by the various unions, because indeed, if there's anything that's intended to benefit their members, it's Senate Bill 512. The key purpose is to make sure that the state fulfills its obligations and matches that money and makes it a secure system so that the retirees and current employees will have a pension that they've earned and paid for. The bill that we're talking about today is a way to protect what our government employees have worked so hard to attain while making future benefits more affordable. It protects what a current employee retirer already has earned. It gives current employees the opportunity to choose from one of 3 plans and to select the one that makes the most sense for them going forward. The world has changed. They have to make a choice going forward as to how to best protect themselves and their family. So I believe Senate Bill 512 accomplishes the twin goals of reducing the amount of money the state must contribute to the pension funds over time, while at the same time improving the financial health of the funds. In closing, I ask you to consider the following. This vote will never get easier. Those in opposition will never be for pension reform, as clear and necessary as it is. All other issues currently being considered, casinos, cameras in Chicago, I don't know what else you folks have before you, but whatever they are, will only affect a special or a limited interest of a part of Illinois or its population. Pension reforms will favorably affect all of our citizens and improve the health of the state. Pension reform will stop the bleeding of dollars from education, from care for the elderly, for the helping the disadvantaged in the schools that take care of them, battered women's shelters, and a whole host of other things, all of which are crying out for help and funding, and you know the story better than I do. So I suggest that failure to act now will only increase the unfunded liability of the pension funds, another $7.5 billion. You've heard us telling you that for some time. Waiting until next spring will lead us to, we can round the $85 billion up to $100 billion. It'll happen or it won't. unfunded liability is overrunning us. This vote will never be easier. I urge each of you to vote for the passage of this bill in committee and hopefully if and when it gets to the floor. Thank you very much for listening to me.
Thank you, Mr. Fainer. The intent of the chair is to ask questions of this panel and then bring the next panel up of opponents, and so that the people in the audience can be ready. That would be Henry Bayer, Michael Kerrigan, Andrew Bo Davis, and Bukola Bello. So we have questions from members of the committee for this panel. Representative Singer.
I just have one question to make sure that we're clear on this. The current Tier 2 will no longer be. Everything goes into one system. Am I correct? And the new employees that are hired after 2011 will now become all in one system. Is that correct? But not Tier 1, right? Okay. And the part of the problem we had with the new employees after 2011 had to do with how the benefits were calculated, so that's being taken care of too. So now we're not to the point where, it looks like a money purchase plan would be a better option than not. Okay.
Representative Neckarts.
Thank you, Mr. Chair. Leader Cross, does the House Amendment 2 affect any of the provisions in House Amendment 1 with regard to the pension systems outside the state pension systems? Are those still covered by this?
Still have Cook in the city, Cook County in the city.
Okay. But the solutions that are proposed in Amendment 2 work for Cook in the city? I don't know. I feel like those are systems that have different parameters, different rules, different histories than ours, and so to try to put that round peg into the square hole continues to be a problem.
It's a fair question. My understanding is that the city and county have looked at the bill and the amendment, and to the best of our knowledge, they're not opposed to it.
And put another way, if I may volunteer, if it is not out of order, we've contacted and talked with the principal people that work for President Preckwinkle and Mayor Emanuel, and they are aware of what's in the bill. They wanted to maintain and be included in the bill.
Okay, thank you.
Okay, one question, Leader Cross. One of the beauties of Senate Bill 512 when you first introduced it was that the state would be responsible for 6% of everyone's benefit, whatever tier they ended up in, okay? Now with the recalculation going forward, it seems to me that there may be a chance in the future where the state contribution would have to be more than 6% if we are freezing the employee contribution at 2% above what the calculated one is for the first 3 years. So in years 4, 5, and 6, and we do make it, going into the future every year after 2017. And my question would be, and I certainly plan on being supportive. I've enjoyed working, through the summer with you on this, but would you be willing to look at that to say, because this could put us in a position where the people who stayed in Tier 1 would be getting a much more significant contribution to their retirement than the other tiers?
That's definitely a concern that's been raised with the bill, but it's something that we looked at as an equitable standpoint, is to not make contributions go through the roof in later years and to give some certainty to employees who are in Tier 1 and wish to remain in Tier 1.
Yeah, that question certainly came up enough that I understand the goal behind it, and there's nothing that you would say that in the future, if we look at it where it's getting out of whack, where there's one group that's going to significantly, have a better contribution, could you at least assure me now that you would not hesitate to look at that in the future if those numbers came out?
I think we've seen on this issue, it would be easy to take a look at it, and we could correct it without much problem.
That's why I support your
point, I mean,
vision.
it's a legitimate concern, but but Kevin, I think the recognition is that the fear of this, and you're dead on with your point and your analysis, but if we're going to pass something and we're going to get support from people, from both chambers and both sides, I think we're kind of addressing the reality of the situation. It may need to be addressed down the road, but I think we do first things first.
Okay. And Representative Neckert just asked you a question about the city and the county firms. This recalculation method does not apply to them, correct?
They have a full count every 3. They recount every 3 years. City and
Okay,
county.
but is the limit, we don't impose that
Yeah.
limit on them?
No.
Okay, they do it through their formula, their current formula. Okay, thank you. Representative Mayor, did you have a question at this time? And then Representative Neckwitz will be doing a
If I
follow-up.
could, has anything been changed regarding the legacy costs, other than perhaps with the change that there might be more of a legacy cost? I mean, sort of, I know you've explained the differences, but how are we addressing the 85 billion? I mean, how are we dealing with that? You know, are we going to use our, the gaming money and
No.
everything, and,
It's a great question, too, Representative. As you know, that's the current payment for the unfunded liability. What we've tried to do under this bill is level it out between now and 2045, and the state absorbs the 85, and it ends up being in the ballpark of about $6 billion between now and 2045, with some variation, but the idea is to stabilize that and bring that ramp down. And so, at the end of the day, we take care of the 85, so regardless of how we got here and whose fault it is, we're handling it. Moving forward, we're starting, in essence, a brand-new plan, and this is, we're trying to figure out, say, here's the cost going forward, and these are the approaches.
but this bill, you don't ever conceive that this bill will address how we're going to absorb it.
We're going to pay it out of GRF every year, from now to 2045.
Okay.
And there's nothing good about any of this, but the beauty of it is that 6 or 7 billion versus 11 billion or 15 or 19 or 23 is a better alternative. That's the only way, you can't, I don't think you can sustain that ramp, and therein lies the problem.
Thank you.
One other point, that there was a document going around that said that the original bill would cost $30 billion, cost the state an additional 34 over and above all this. COGFA came out with a report yesterday, or the 3rd, excuse me, that said just state contributions with respect to TRS alone will be reduced by $47 billion compared to the current law, savings of $47 billion. Now, that number is going to change a little bit with Amendment Number 2 because of the point Kevin's made, but nevertheless, it came about as a result of independent actuaries at COGFA analyzing the bill the way it was, and I'm sure they'll look at it as with respect to Amendment 2, but it's a different number than what we were seeing originally from TRS, saying there's an additional cost. So just wanted to point that out.
Thank you, Representative Neckwitz, for a follow-up, followed by Representative Daniel Biss.
Thank you, Mr. Chairman. So I just wanted to follow up on Chairman McCarthy's point about, so it's my understanding, since we're capping the employee's contribution and we're capping the state's contribution, the only place to pick that up is to add to unfunded liability. Is that accounted for in the $6 billion that you described?
Yes.
Yes?
Remember, it fluctuates in that 6. I'm using that as just a general number.
Okay.
But it's going to fluctuate, yeah, we picked that up. I mean, we're not stopping the bleeding completely with this approach.
Right.
I mean, there's going to be some continuous bleeding, but it's from an actuarial standpoint, it's not the perfect bill.
But to your mind, then, that moving to something like this, where we do add to the unfunded liability to a greater extent than we did under House Amendment 1, is still an approach that you think is more palatable to folks around here?
We're trying.
Okay.
We're kind of betting against ourselves
Yeah.
to a certain degree. Some people have opined on what they like. It would have always been nice to have more input. So this is an attempt to address some issues we've heard from folks, and a lot of
Okay.
it from members.
So, I feel like it's important that that this discussion happened, because I can imagine that, the story that gets out is, well, all that this House Amendment 2 does is add to the unfunded liability, and that's what people will understand about this, and the public will say, well, why on earth would you do that? But I think it's pretty much all the approaches we have to dealing with this increase unfunded liability. It's just a question to the extent that we do that, and then how, but having an approach to getting it paid off, I think is critically important.
Thank you, Representative. Representative Biss?
Thank you, Mr. Chairman. I just wanted to follow up on this point about this. There's like a hole being blown in the funding mechanism by this amendment. The size of that hole, I presume, depends on the number of people who choose to stay in Tier 1, correct? So what assumptions are you basing the 6 or 7, where does the 6 or 7 billion come from? What's the story with that? Can we hear more about that?
Dia Meyer from the Civic Committee. Hi, thank you all for having us. you will recall, this is a point that had been raised many times during the consideration in the spring, as well as during the summer in discussions with Representative Biss and others in terms of ways of looking at this. I think the whole goal of this is really a broad systematic reform. So you're looking at providing a long-term solution that stabilizes the amount of money of the state that goes in to fund the $85 billion, which is estimated, the goal is 25 to 30% of the big three revenues over time. As you look at this, it goes up much higher. So that's one. And then the other piece is the funding of the current employees and as well as the retirees, as well as new people coming in. The feeling is that by capping it, you're looking at, let's use TRS, for example. Right now, they're paying 9.4. In the year of implementation, they're looking at 13.77. So they've got an increase. You've got 6% that's going in from the state. You've got the increase of 13.77 on top of that goes in to fund the pensions. And then 3 years later, you've got a reset that's capped at 2%. So you're looking at teachers putting in 1577 on top of the 6% the state's putting in. So you're looking at 2177% going in to fund that benefit. And then as time progresses, those are the more expensive ones that will be retiring, and you've got a smaller population as time progresses. You've got a smaller number of people that are going to have to pay that higher amount that would go to any unfunded liability, the difference between, say, that 2177 and 23%. 2% on a smaller population, so that the size of the dollar amount is not significant, it's not significant, and if you want to talk about sort of the range, but we don't view it as something that's going to break the bank. The goal is that these numbers will be recast before it gets implemented. The systems will recertify what the numbers look like. You got 3 years later to look at it. You've got a 2% cap, and then same on the Tier 2 piece. So I think that, at least at the beginning. So I don't think you're looking at something that's going to put a huge hole through what's estimated to be a 25 to 30% of the big three revenues. We think it's probably a smaller increment of, can you guesstimate sort of, this is Brian Septon.
Hello, I'm an actuary, and I think the point that Dia Meyer is making is correct in that the population in Tier 1 over time would decrease. It's a closed program. There are no new entrants to it, to the question earlier. And the migration assumptions that the teachers' retirement system and COGFA put out indicate as well that they do expect migration out of Tier 1. And so to the point about would the normal cost of the up to 15.77 plus 6%, would that be sufficient to fund the benefits? I think Representative McCarthy raised a very good point that from an individual equity standpoint, yes, the people in the plan may, if their normal cost is, say, 22, you might look at them and say they may have a smidge contribution over 6%. From a standpoint of the impact to the budget, projections would indicate that would be a much, much smaller portion of payroll, and therefore the notion, I think the notion would be correct, it would be absorbed by the unfunded liability. I'd be hesitate to call that blowing a hole in the unfunded liabilities. We expect the payroll to decrease significantly out of Tier 1.
Especially as the population ages.
Oh, that's right, because we're talking about...
Ages and the newer generation comes in.
Right, because the issue would be in fiscal 17, fiscal 18, as the Tier 1 population continues to decrease over time as people retire out of it.
I don't want to step on Representative Biss because he has the floor right now, but as this Tier 1 group gets smaller, does that add to their normal cost, or does that subtract from their normal costs?
So I think you're asking is that if the Tier 1 group, if it's a closed group and the Tier 1 group simply just ages and gains more service under the plan, under the actual method that's required by the state known as projected unit credit, by definition their normal cost will increase each year as the population ages and gets and gains more service. That was the initial reasoning to have the triannual recertification, in that you want to catch up to what the population actually is. I understand from considerations that the Civic Committee explains to me that perpetual triennial recertification was taken out of the bill, but that would be the intent, to be able to catch up with that. But again, to the point that you have to look at 5 to 10 years, and the payrolls are much smaller under there.
Okay, I'd like Representative Biss to continue.
Great, thanks. So just on this point, I don't know when this amendment was developed, since I only saw it yesterday, but were you able to run the calculation of what happens if nobody migrates out of Tier 1? What impact this amendment, this cap, would have on the additional unfunded liability? or just what the state would owe annually till 2045 if everybody stays in Tier 1?
So, and I can only speak for myself, saying no, I have not run any numbers on that. I will state that the current normal cost as published in their fiscal year 11 pension valuation report was 19.4% of payroll. And so when you take off the state 6, as this bill allows, then the employee contribution is just around this 13.7 that I believe is written into the bill. That because Tier 1 is closed, that would be expected to increase over time. And I think you're saying that very long term, if the participants stay in Tier 1 over 30 years, that 15.77 might not be adequate. That's a possibility. You know, I do point to COGFA and the systems both making estimates that there would be significant migration out of Tier 1 by choice. But I think if we did in Tier 1, that could be a possibility. But no, I have not run the numbers on that.
Okay. I'm reading here Section 99. It says this act takes effect July 1st, 2012. And I also understand that that's the formal effective date of the bill, but it actually starts doing stuff a year after that. Is that correct?
The bill is written. Had the bill been passed in May, we would have had a year implementation between last year and this year. In light of the halfway through the fiscal year, what we wanted to do was be able to be in a situation where we've got an implementation date within the just after this fiscal year, and you get a year and a half in essence to be able to implement the bill. I mean, one of the issues, as we've all talked about, is we want to make sure that what we're doing is actually provides employees a good retirement plan. And that in doing that, because of the choices, it is a little bit more complex than what's been done historically. It's been done in the private sector and other places as well, but that it gives both the systems and the employees time to be able to implement the changes and understand, recognizing what the financial implications are to them and their families. And so that is why it has the time period in terms of implementation. In addition, with respect to the legislature, there is a provision that basically you need to make sure that people, when they're coming into term, have an option to be able to do it. And with the election coming up, there are two implementation dates, one between what happens under GARS as well as what happens under the other systems.
I understand that, and I appreciate that. I guess my only point was that in light of the combined facts that on the one hand, the committee wasn't made aware of the amendment until yesterday, and on the same hand, the actuaries haven't even had a chance to run the worst-case scenario, and given the fact that the bill formally takes effect more than a half a year from now and then actually starts doing things a year after that, I'm a little baffled about the urgency about doing this week as opposed to, for example, early in the spring session. But thank you very much.
Thank you.
Representative Poe?
Just quickly, once this gets instituted, how's that percentage stack up against percentages around the United States? Will our employees and teachers and employees, will we be the highest percentage paid out of their paychecks?
In terms of the national comparison, in terms of our teachers and what they pay, right now, at least some of the information that was provided to the pension working group showed that we were somewhat higher right now in terms of the benefits for the contributions that go in. An important point also to consider when we're looking at contributions to the pension fund, for example, on the part of the teachers, is that 62% of the school districts pick up as part of their negotiation process the teachers' contributions to the pension system. So in addition, to the extent that people want additional savings, there are also many school districts also offer 403B plans to allow people to have additional savings.
And then under this plan is the current Tier 2 system with the age of retirement at 67. Does that stay in this bill?
That does stay in the bill, but the big change on this is that under Tier 2, under the current system, you have the employees putting in 9.4%, the state making up the difference between that and potential normal cost. The pensionable wage base, which is set at 106.8, grows at half of CPI, and that over time, with the growth of wages, either Social Security or otherwise, you end up in a system where it ends up being employee pay all, with their contributions, them getting a benefit that is less than what the contributions are that they're putting in, and that what we've done with this is change the pensionable wage base so that in essence, the employees are getting a 12% benefit as opposed to one where they're putting in 9.2. It lowers their contribution and also increases the benefit they get over time. So that what it does is actually make it a good, decent, defined benefit program that people have for their lifetime going forward.
So did you change the years of being funded in a pension system like now? If you teach, let's say a teacher starts at 21, they can be fully vested maybe by the time they're 60, 61, and then they're going to teach till they're 67. Is there any provisions, if they keep paying those percentages, is there any provisions that they'll enhance their pensions at all?
I'm not sure I
Right now,
understand.
you're vested after so many years, and you hit a maximum of a percentage.
Right.
Well, right now, with a Tier 2 setup, you can actually max out probably, well, a lot of them are hitting it, 60, around 60-ish, but they got to teach till they're 67. Is there anything in this new bill that will go ahead, because that was a complaint we heard about when we passed Tier 2, was that we're going to have them teaching anywhere from 5 to 7 years. They're going to be paying in their pension systems, but there's no enhancement for them to pay that extra money in. Is there anything in this bill that would encourage them to keep paying, or is it they stop their pension payments when they're fully vested? Is there anything like that went into this?
The one point for clarification is the retirement age in Tier 2 is as early as 62.
Yeah, I understand the
okay,
penalties and
so-
all that. I
right,
understand
okay.
all that.
Yeah, the second point is that for teachers who are currently in Tier 1, they would be able to accrue they'd be able to accrue additional amounts under Tier 2, which would allow them to allow them to sort of accrue up against that 38 years of service that maxes you out at 75% again. So you'd be able to start fresh with service under Tier 2, such you can earn your benefit up in Tier 2 through the end of your working
Okay, so you
career.
drop out of one, go to two, that lasts 5 years?
And that, under the plan, every 3 years, an employee could move from Tier 1 to Tier 2 to Tier 3 if they want.
They can move up, but they can't move back.
Correct.
Okay, thank you.
Any other questions from the committee? Just one for the sponsor. Could you, concisely as possible, tell us how this affects the currently retired members of any of the systems that the bill affects?
As concisely as I can, it doesn't.
Thank you.
DOESNT, doesn't.
The chairman is grateful to have that on the record. We will now go forward with
Thank
the
you.
next
I want to
panel.
make sure I say it again. It doesn't.
Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.